what is the good. But nobody has placed his oath. There is not supplied on supportive affidavit anything. Just place both the court in the at the time of middle of the hearing.
Yes, that was accepted by the board.
Accepted by the court, and
you were not parties to the writ petition.
Board has court has accepted. My humble submission is, and board as usual did not do anything, kept quiet. Board did not object anything.
Yes.
But board did not object. That doesn't mean it is. I cannot object. Appeal is a continuation. I'm very short on that. It is a document prepared by a private party without not supported by any oath or affidavit anybody. Now I'm going to see what the purpose of this 123 starts. Page 123. Serial number 1. Heading 2014 TATE and 2016 recruitment process. Vacancy was 42,949. That figure is correct figure. Similar. Now, what is the first objection? This is primary TATE 2014 লিখিত পরীক্ষা OMR sheet তৈরি এবং তার মূল্যায়ন করার বরাত পায় বাসু রায়চৌধুরী বাসু অ্যান্ড কোম্পানি। কিন্তু লিখিত ভাবে পরীক্ষা নিয়োগ আবেদনপত্র এক্সেট্রা how is it relevant?
No, we have taken note. This is an unauthenticated list of documents which reliance was placed by the learned judge, which ought not to have been done.
Yes.
This is your court. Yes.
Yes. So, but this is first serial. The primary TATE, there's a corruption or illegality, not in the 2016 selection process. Please see the first document. Primary TATE 2014. That was prepared by Basura and company. How is that relevant while considering the validity of...
That is because that TATE qualification was essential qualification for
TATE qualification is different thing. TATE qualification is not challenged here. Different period.
No, that is not being said here. It is only an information. Are you disputing this information?
Yes, certainly.
So you mean to say no TATE?
This is the primary TATE examination results is subject matter of another writ petition pending in this court.
Maybe.
Pending.
But you are not disputing that TATE 2014 eligibility was the subject matter of selection process.
No, sorry.
Yes.
That's right, my lord. But eligibility, there is no complaint that...
All right. There was no complaint as regards the TATE.
No allegation in the writ petition that the persons who were qualified by 2014 TATE were not eligible.
That is not the...
Then why? The question is all the corruption, etc., allegation also find a petition is all regarding 2014 TATE, not regarding 2016 election process.
Yes, that is also included, Mr.
Therefore,
you understand that TATE 2014 was not the subject matter of challenge of this 2016 recruitment. This ought not to have been taken into consideration by the judge, more so when it is not supported by evidence.
Judge is legitimate, obliged to lordship. Therefore, when my lord thinking of corruption and say that when I see a corruption, should I keep my eyes shut? Corruption, say committed by A, on respect of A, for that B will suffer. There is no charge of corruption in respect of 2016 election process. I shall come to repeat, show you, lordship. I have to disabuse my lord's mind about corruption in 2016 election process. Is there an allegation in the petition? I'll come to that immediately. I'm now come to me of this. See what concoction is there in this petition. Please come to page 237. My lord wanted me to make submission on this. It is not. It is
No,
not.
that we will ask the board, Mr. Mitra. We thought of placing that, but that the board should answer to us. We are not going into that. So
Yes.
will you take us to the judgment? Do you have that corruption? Will you read that? Will you place that? Judgment.
Huh? I'll come to that. The judgment. I'll place by 1822. I'll only place that now, right now. I'll place it. I wanted to show you, Lordship.
As you wish, Mr. Mitra.
No, then can you, Lordship, raise the question 237? See,
237, we are not asking you now. Because you are not parties.
But I have to show. Lordship may not ask. I have to support my case. That these petitioners made an illegal when in a untenable charge. What they are showing, they're manipulating documents. I just show you, Lordship.
Are those your grounds?
These are manipulated documents. This is not original RTI sheet. See this document. It's not original RTI sheet. It's not signed by anybody.
That I pointed out to you now.
This is not in the pleading apart from that. RIT report against it, retype by them.
Is that your ground of challenge?
It is not
your application. Is that your ground
of challenge? It's not an affidavit.
In your leave to appeal which you preferred, did you take this ground? Mr. Devbarman, why you are saying to Mr. Mitra, is that a ground in your appeals, leave to appeal? No, I'm saying, is that a ground?
That was not available to the appellants at the time of preparation of stay or memorandum.
Very good. That will be your reply only. We have not asked you to deal with that document. That is what we are asking.
This last question, Lordship asked me to. What may I shortly show me that incorrectness of this? What is there asking for question? What is the question? Similar. One thing will be clear. Read one bar. Siliguri district one. What is the question to RTI? Just once a question. How many candidates, trained and untrained? Can you see one paragraph? 237, question, all the same question. Question 2, how many candidates, trained and non-trained, para-teacher, plus case petitioner? What is the case petitioner? You've been told. It is a case petitioner. Have been appointed by Siliguri district school and primary school, including all categories of all medium with memo number blank dated between 24/9/2016 till 11 January 2017. So 2021. Selection process in 2016, my lord, kindly note, is stopped in April 2017. But they're asking for how many candidates after 4 years after selection process stopped, how many candidates were untrained. So why? This is to what purpose? Vacancy was 42949. And according to the learned judge, 32,000 persons were employed to fill up this vacancy of 42,000. Therefore, no employment given beyond the vacancy limit under the 216 selection process. On their own admission, there is nothing given. Am I clear, my lord? The one ground is you are given employment busting the vacancy limit.
So your contention is there was no appointment beyond the vacancies advertised.
Vacancy beyond vacancy limit in the selection of 2016.
Very good. What is that number according to you?
This is the number they have given 4 to 9. According,
you say we will.
I say according to the judge, 32,000 employees. That is the order.
Yes.
Therefore, 32,000 persons are employed against vacancy of 42949.
Yes.
So there is no question of over employment. But I think that
that is not a ground in the for setting aside the selection process, Mr. Mitra.
that is not the ground.
Not the ground.
That is not the ground. Very cool. Then I'll stop here.
Yes.
I'll come to that.
That is in paragraph 18.
Then Miller, I shall go as by my lord wants me to. Can you paragraph 17, 18, 19 of judgment? Yeah, judgment. If my lord agrees this file has no effectiveness, I'll stop there.
Because why do we say so? Because in the writ petition which they filed, subject to correction, we
Yes.
didn't find any allegation that it was appointment was above 42,000. On the contrary, they said that there are existing vacancies. You accommodate us in those vacancies.
Okay, I have no objection to
Yes,
that.
that is
What objection can I have?
exactly.
I am not there. I'm not stopping their employment.
No,
They have stopped
saying-
my employment. But I'm not vindictive. Let them have as many appointments as they like.
They will become my friends. Later they will become my friends.
আমার চাকরি খেয়েছে বলে আমি ওদের চাকরি খাবো নাকি?
Mr. Gupta, that is a fact, na? That there was no appointment beyond 42,000.
No. That's not the
That
case
is
of
what-
any. That's not the case of any.
That they will explain to us. They will explain.
No, we are in the selection process of 2016.
Yes.
Admittedly, the vacancy of 42,000 odd and appointment made according to the learned judge 32,000 only.
Yes.
So therefore, no question of. So
Excess appointment.
apparently, Miller, after April 2017, further appointments are given, maybe by the board. Maybe that is their case. That is their case.
That is by virtue of court orders.
That is their case.
17, the appointments that were given were pursuant to the court directions specifically.
That is it.
That was not told by Mr. Dotto. In his argument, this point was not. Anyway, you will give your reply.
Now, Miller, Lordship is now verifying the selection process of 2016. And my lord, will you please to ask me to consider paragraph 17, 18, 19 or only 18, 19? 18 to 22. Please similar was 18 to 22. Can you page 623 of volume 1? What is the corruption involved in 2016 selection process?
Mr. Mitra, I'm sorry. It should be from 17.
Right, that's my lordship. 17 or not 17. Please, that's it. From the gross illegality in the selection procedure in the recruitment exercise conducted of exercise 2016 conducted by the board, it is clear that board is official, including former president. Did it? So, gross illegality in the selection procedure. What are the gross illegality? As shown in the judgment? Six. First one, 832 candidates below the lowest mark. I've dealt with that.
That you have
This
said.
is that's a wrong low mark. Gross illegality, you were confined with judgment. On what ground court holds certain illegality?
That you have explained to us.
Yes, illegally, not corruption. Illegality in the procedure, violation of rule, etc. Corruption is a media creation. Now let's see. Six instances given. I shall deal with each and every one. So it is not sustainable. What is sustainable? Suppression by the board. Why? Because board has not produced a document, which according to judge I have shown the document was produced, disclosure particular given, but my lord, kindly see as a judge, if the respondent does not, is suppose respondent suppress a document, what's the consequence in law? Petition will be allowed. So, respondent has suppressed a document according to learned judge, which is incorrect on fact also. But what's the but that petition will be allowed by making orders which are not prayed for in a petition. Law is right. Let me finish this.
Yes, the paragraph, then you argue.
Okay, very good.
Second person, please place.
The election process illegality conducted board is clear. That the board, its officials, including its lower in former president, Mr. Manning Potter, I'm told is a one who is now in custody after arrest by enforcement directorate for transaction of huge money in the recruitment procedure. In which procedure? Lordship doesn't say in the selection procedure of 2016. That's because he was in connection with TATE 2014 selection procedure. And he is now released on bail, he is not yet been convicted, found to be convicted. Now, my lord will consider whether it is relevant to consider this factor while deciding the validity of the selection procedure 216. That the president was arrested and in arrest in connection what? Suppose he had committed theft. Yeah, he arrested for that. And that will vitiate the selection process, a public selection process. He does not say he has been taken in custody because of something wrong done by him in 2016 selection process. Doesn't say that. They come to the next, if I read on. If he said, Lalne just said, if a president is arrested for doing something wrong in respect of 2016 selection process, I could understand the relevancy. No. Then it is mandatory process. Conducted the whole affair as a local club. Now is gradually coming to light by investigation of gradually coming to light by enforcement